Kenya? What is the state of our morality in terms of our constitution? We have provided a case, and that case will form my next line of submission, the case of EFF, Economic Freedom Fighters versus National Assembly, 2018 South African Constitutional Court. Which way for Kenya? The first petitioner has gone through what happened in terms of the process. It paints to us a very worrying state in terms of the health of the democracy that we have in this country called Kenya. This is a clawback in terms of the Constitution and the state of our democracy, culminating into the Constitution 2010 that was characterized by huge cost for the ordinary Kenyans. People shed blood, people were killed, and people died. We should not lose focus of that. And that state of affairs painted by the first petitioner leads me to pose this question to the court. Did we need specialized rules and procedures for this process of investigations and hearings to be established before the process commenced? Did we need specialized rules and procedures before the process of impeachment investigations and hearings commenced? That is a question, your lordships, your ladyship, this court must answer. And like my elder senior counsel, Elisha Ongoya, I'm relishing to read the answer to that question from this court. On our part, we respond in the affirmative. Yes, we must, and we needed to have specialized rules before the impeachment began, either in form of a specialized code, or it ought to have been mutually agreed between the parties. Parliament ought to have sat down with the Deputy President and agreed on the rules of procedure, or else we should have had a specialized code. For the following reasons. Number one, protection of constitutionalism and the rule of law. Pre-established rules ensure the impeachment follows constitutional norms rather than political convenience or sudden improvisation. The Speaker extends it to Saturday. Parliament says no. We will do as we wish. Error. Kosa kubwa. Secondly, prevents abuse of power and political witch hunts. Clear procedures make it harder to weaponize impeachment and partisan revenge for short-term political gain. Number three, guarantees of fairness and due process. The office holder facing impeachment deserves predictable procedures, notice of charges, a right to respond, and an impartial hearing. Number four, enhances legitimacy and public confidence. When procedures exist beforehand, the public is more likely to trust the outcome as lawful and not pre-engineered. Public trust, public confidence. Next, it ensures institutional consistency. Preset rules prevent changing procedures mid-process to suit the circumstances or the person under investigation. We are giving you, was it 10 days? Then midstream, we are going to continue, irrespective of whether you are sick or not. Rule of law questions. Can we operate a serious constitutional interrogation such as an impeachment in that manner? No, we say. promotes separation of powers. Structured procedures reduce institutional conflict by clarifying the roles of parliament, courts, and other bodies. Number 7, provides clarity and efficiency. Investigations and hearings move faster, are more coherent when procedural uncertainty is removed. Number 8, protects minority and dissenting voices. Those that dissent, and for aught we know, perhaps we had dissenters, people who are willing to vote against the impeachment. We may never know because the rules lacked. Formal rules ensure minority members in legislative bodies can participate meaningfully and are not outshot by majorities. It creates objective evidentiary standards. We had objective evidentiary standards from the courts. If that was applied,